Hi there, my name is Carrie Lutringer and I'm an attorney at Wadler, Purchase, Hundle & Kurlich. And today I'd like to talk a little bit about letters of intent. Now, buying or selling a business can be a daunting undertaking for anyone, no matter if it's your first transaction or if you're a veteran at the process. Typically, the way the transaction will begin is buyer and seller will get together, strike a deal, come to an agreement upon the basic terms, and then shake hands and decide to go on down the road. So the typical next question is, what do we do to document our agreement? Well, one of the best tools that I found to help expedite the negotiation process and kind of get everyone on the same page in terms of the agreement is a letter of intent. Sometimes it's also called a term sheet. A letter of intent is basically a document that is non-binding in most respects, not all, and we'll talk about those provisions that are typically binding. But for the most part, it's going to lay out the basic terms of the transaction, so there are no surprises when the definitive documents or the purchase agreement is drafted, and both parties have a pre-agreed understanding of what the terms of the deal are. So the types of deal terms that are going to be covered are basically, for one, the structure of the transaction. Is it going to be treated as an asset sale or as an equity sale? What's the purchase price and how's it going to be paid? Is it a cash deal? Is there some financing component, either through a third party? Is the seller going to finance any portion of the transaction? How is the purchase price going to be allocated among the assets if that's the preferred structure? Also, whether or not the buyer is expecting the seller to make any specific representations or warranties. Reps and warranties are basically statements that the seller is going to make to the buyer about the quality of the company and the business. So there'll be things that cover ownership. The seller will say that they own the company or the business. They've got the authority to sell or enter into the transaction. They'll make representations and warranties about the quality of the assets in terms of condition, whether or not there are any outstanding loans or liens, whether there's any litigation pending against the company, and similar types of issues that any buyer is going to want to know about before they decide to close on a transaction. In addition, there'll be any closing conditions identified that the parties want to agree upon. So for instance, if permits need to get obtained or if loans need to be paid off or certain agreements need to be made with customers, the things that need to be handled before the buyer is going to be willing to sign off. And then what sort of goes hand in glove is what will give the buyer the opportunity to terminate if those closing conditions aren't met or if they otherwise want to back out of the transaction. You may want to also cover matters that deal with employees. So for instance, are employees going to continue to be employed by the new buyer? Are there certain key personnel that need to stick around in order for the buyer to want to go through with the transaction? In addition, the buyer will oftentimes want the seller to sign a non-compete agreement where they agree to not compete with the business that they are selling for some period of time or not solicit customers or employees of the company after the closing of the transaction. In addition, there are other logistical matters related to the transaction that will need to be addressed. So for instance, in the diligence process, which is the process in which the seller kind of opens up the books and allows the buyer access to the company to do their own investigation as to its quality. How is that going to be conducted? Who's going to have access to the materials? Is there going to be any kind of confidentiality requirement required? What personnel need to be available to answer questions of the buyer, etc. And then also the expenses of the transaction are usually described as to payment responsibility. So typically both parties are responsible for their own costs, but that can be negotiated however you like. So as I mentioned, the bulk of the information in the letter of intent is going to be non-binding. However, there are a couple of provisions that are typically binding on both parties. One of those being confidentiality. So the fact that the parties are negotiating a transaction, that's typically something that the parties will want to keep confidential. Also, any information that is disclosed to the buyer, the seller is going to want the buyer to maintain the confidentiality of that information during the period of due diligence and thereafter. In addition, there's also typically an exclusivity provision, which basically is going to prevent the seller from soliciting offers from other buyers during the time that the buyer is conducting their diligence or the period of time during which the parties are negotiating to close the transaction. So a letter of intent is not a document that's going to be required by either party to close a transaction. I do find that it's a useful way to get the parties kind of organized and get a game plan moving forward. So if you have any questions about what I've discussed in this video, or if you're interested in having us help you put together a framework for a term sheet or a letter of intent, we're happy to help. You can reach us at our website, www.wphk-law.com. Thanks so much for your time.